I mean, it is a violent assault. It is not.
I think most people think of rape as being sexy.
Let's take a short break.
Think of the fantasies.
We're going to take a quick break. If you can stick around, we'll talk more on the other side.
You're fascinating to talk to.
If she says that she has evidence of DNA, why can't we ask her about that? I have the dress. I've got Trump's DNA on it. Great, go get it, prove it. President Trump going to the Supreme Court. This is the order that came down from the Court of Appeals, not a good ruling for the president. It involves the case of E. Jean Carroll, the woman who claims she got Bergdorf at a dressing room at Bergdorf's, and her story is as fanciful as they come. But this came down from the Second Circuit, which means the next stop from the president is the Supreme Court to take this back up to say that Trump's trial in this civil defamation and assault allegation was erroneous and should be reversed or remanded. You can see this is the opinion that came down, but Trump's people have already promised to appeal this. The Gateway pundit got in contact with Stephen Chung, and Trump's representative said the American people have reelected President Trump with an overwhelming mandate, and they demand an immediate end to the political weaponization of our justice system and a swift dismissal of all the witch hunts, including the Democrat-funded Carroll hoax, which we will continue to appeal. And we're looking forward to that. So it'll go back up to the Supreme Court, and we'll see what the Supreme Court says about this. But you remember this case, we covered it at length. This is E. Jean Carroll, who was contacted by George Conway at one of their anti-Trump parties. They have these weird things with Molly Jong Fest where they all go to somebody's apartment in New York, and who knows what they do. But I can't even imagine what it smells like in there. But they're all in there just doing whatever they do at these things. And then Conway met her and was like, oh yeah, she's crazy, totally. So how about I introduce her to some other lawyer called Roberta Kaplan? Then Roberta Kaplan says, oh great, you're here and we can sue Trump for defamation because he says he never met you, but we have a photo that you met her in a photo lineup. So that's good enough, defamation. And he said something about it. So we make the claims and they entrap the whole thing. Then they created an actual adult survivor statute and enabled Trump to be litigated and prosecuted civilly for a made-up claim. They wrote a law to enable him to be charged with civil offenses. And that's exactly what they did. So Stephen Chung says, we're going to be appealing this thing. If you forgot who E. Jean Carroll is, well, this is who she is. This is the woman who testified in front of the New York jury. And by the way, they found Trump liable for defamation and in another subsequent trial for the old DJ Diddles, the grab him by the purse situation, because he says on a tape at some point that he's allowed by women to grab them by the purse, not non-consensually, but that tape was played over and over and over. And so they said, oh, that's good enough for Trump. We'll just say he grabbed her by the purse. Even though there are no corroborating witnesses, it's her word versus Trump's word. There's no security surveillance. There's no store witnesses. The only two people that she talked to after the event were very lukewarm in corroborating her testimony because they know she's crazy. But this is what it all hung on. And by the way, the jury didn't believe her. The jury came back. She said that Trump also did the hibbity-dibbity with, the thing down there. And that never happened. The jury said she's not credible on that. So there was no R, but there was a grab him by the purse, which means the jury didn't find that she was telling the truth on that or that she was not credible. And they just gave her that other one because they hate Trump. Here she is.
I call it the mouse house because some very distinguished mice live here. Kahneman lives in the kitchen. Tversky lives in the bedroom. This is my shed. And on that side are the books that most influenced me growing up. On the door are the lists of my dogs. Marky, Fortuna de la Spunky, Heidi, Tits, Bloody, and Hepburn. The streams and the rivers were dry. It so horrified me that I came out and started painting the rocks blue to indicate that there was once a river here. And then after I got done painting the rocks, I just sort of walked over here and then did that tree and then did that tree and then I did this tree.
All right, so that's who she is. Now, that's just maybe a quirky, spunky, weird person, weird lady, whatever. Maybe she's kind of, charming in a way because she just does whatever she wants and paints everything. Hey, she's crazy. She just paints everything. Oh, yeah, I know her. Okay, fine. But she had all sorts of other allegations and she was making claims against many other people. And she had statements like naming her cat vagina and all sorts of weird sexual proclivities that had come out that were never allowed to be introduced at trial to show the jurors. This woman's just a sex weirdo. Here it was her exchange with Cooper when she said the R was sexy.
I feel like a victim.
I was not thrown on the ground and ravished, which the word rape carries so many sexual connotations.
Yeah.
This was not sexual. It hurt. It just,
But I think most people think of rape, it is a violent assault. It is not
I think most people think of rape rape as being sexy.
Let's take a short break.
Think of the fantasies.
We're going to take a quick break. If you can stick around, we'll talk more on the other side.
You're fascinating to talk to.
Cut it. Rape is sexy. You're fascinating to talk to there, Cooper. All right, anyways, here is what the judges said. Before these judges, they say, okay, here's their rationale. This case is coming to us after a 9-day trial. A jury said that Trump abused E. Jean Carroll by grabbing her by the Bergdorf in a dressing room at Bergdorf's. The jury also found that Trump defamed her, okay? By Trump saying, I didn't do these things, that's defamation. The jury awarded her $5 million because they hate Trump. So now Trump appeals, saying that Judge Kaplan, who absolutely loathes Trump, erred in his evidentiary rulings. We listened to that. Now, her lawyer, E. Jean's lawyer, was named Roberta Kaplan. The judge's name is Lewis Kaplan, and they're not related. These include its decisions. They admitted testimony of 2 other women who alleged that Trump assaulted them in the past, who were not E. Jean Carroll, and they also admitted a part of the 2005 recording, that's the Access Hollywood tape, where Trump said he could grab women, they say, without first obtaining their consent. And I think if you listen to the quote, I don't know if it's going to be in here or not, but I think Trump said they let you do it, right? So it's not like, hi, may I grab your vagina? Oh, certainly. Who are you? Oh, you're Trump. Sure. Here you go. I don't think that's how that conversation went. But Mr. Trump contends that these and other asserted errors entitle him to a new trial. Now, on review for abuse of discretion, we conclude that Mr. Trump has not demonstrated that the district court erred in any of the challenged rulings. And so Trump loses, and the trial verdict and the $5 million is affirmed. Here is what they write. It's a per curiam opinion, which means it's the opinion of the court, and it's not any one judge taking credit for it. They say, here's the deal. In this case, after a 9-day trial, a jury found that E. Jean Carroll was abused by Trump at a Bergdorf Goodman in 1996. The jury also found that Trump defamed her when he said he didn't do it in 2022. So you see how this works? Somebody makes a claim, you say, I didn't do it, then they sue you for saying, I didn't do it. The jury awarded her $5 million in compensatory and punitive damages. So she suffered. So the compensatory is to make her whole, and then the punitive damages are to punish Trump, which of course this was all about. So now Trump appeals this, saying that Lewis, the judge, erred in several of his rulings. These are including decisions to admit the testimony of 2 women who say that Trump assaulted them in the past, and to admit the tape where Trump described to another man how he kissed and grabbed women without first obtaining their consent. Again, can you sign this form here before Trump contends that these and others asserted errors entitle him to a new trial. So here's the background. They say, when we look at appeals, the Court of Appeals says we're not going to have a new trial. We're going to look at it through another lens. We're going to construe all evidence in favor of the party that prevailed in front of the jury. That was Miss Carroll. And so we're going to describe the narrative in E. Jean Carroll's eyes, what she thought. Trump didn't testify, and he's denied that he committed any misconduct and that he defamed her. So here's the evidence that they say happened at trial. Now, we summarize the evidence. They say in 1996, Miss Carroll encountered Trump at Bergdorf. At the time, Carroll was an advice columnist, right? She wrote for Elle magazine, a daily advice talk show. They say Trump recognized her, asked her to stay and help him pick a gift for a girl. They thought it was funny. She thought, oh, it's going to be a wonderful prospect for a born advice columnist to get advice from Trump. So then Carroll suggested that Trump purchase a handbag or a hat. Trump proposed they go to the lingerie department instead. Miss Carroll and Trump went to the lingerie department. Trump selected a piece of lingerie and said, hey, Carroll, why don't you try this on? Carroll said, you put it on. It's your color. After some playful banter, Trump took Carroll's arm and motioned for her to go to the dressing room. Because Mr. Trump was being very light and pleasant and funny, Carroll walked with Trump into the dressing room, which she said was kind of an open area. Then she walked in and Trump shut the door and shoved her against the wall so hard that her head banged. Miss Carroll pushed Mr. Trump back, but he thrust her back against the wall, causing her head to bang again. With his shoulder, her whole weight of the body, Trump held her against the wall, kissed her, pulled down her tights, and grabbed her by the purse. Then Carroll kneed off of him, exited the room, and left immediately. Then, within a day, Carroll told 2 friends, okay, within a day, and this was a point of contention, like, when did she call you back in 1996? They're like, oh yeah, right afterwards. Lisa Birnbach and Carol Martin, and these people also hate Trump. They're on record hating Trump. She did not report the incident to the police or share it publicly for 2 decades until suddenly George Conway came and talked to her. Now, while conducting interviews for a book that she was writing in 2017, the account of assault perpetrated by Harvey Weinstein came about. Now, Ms. Carroll, they note, also testified that Trump inserted his MAGA into her no-no place, and the jury found that she did not prove this part of her claim by a preponderance of the evidence. Okay, so the jury even says that preponderance of the evidence is such a low standard. It's like, was it more likely than not? Like 51% that Trump did the P and the V? No, didn't happen. So if that is not believable, why is the rest of the story believable? Well, it's because they hate Trump. So it got nationwide attention, and so Miss Carroll finally decided to share her story. So then in June 2019, New York Magazine published an excerpt from her book saying Trump Bergdorfed me in a dressing room. So she makes a claim. Trump denies the allegations, and he was president at the time. Okay, she says, I got Art in Bergdorf. She says, no, you didn't. I never met this person in my life. She's trying to sell a new book, the court admitted. That should indicate her motivation, okay? Trump says it should be sold in the fiction section. Shame on those who make up false stories of assault to try to get publicity for themselves or to sell a book or carry out an agenda. Just like Julie Swetnick, who falsely accused Kavanaugh at the time. It's just as bad for people to believe it when there's zero evidence. Worse still, for a dying publication like the New York Post to try to prop itself up by peddling this fake news is an epidemic. It's a disgrace, and people should pay dearly for these false allegations. Then Trump denied it again. He told another reporter and someone else, he said, I'll say it with great respect, okay? Number one, she's not my type. Number two, it never happened. About 3 years later, then in October 2022, after Trump had left office, Carroll said, we're going to sue him. Trump posted on True Social. She said, I'm going to sue him for R and assault. Then Trump posted on True Social. He said, this Miss Bergdorf Goodman case is a complete con job. Our legal system in this country as well, but especially with Peekaboo James, it's a broken disgrace. You have to fight for years and spend a fortune in order to get your reputation back from liars, cheaters, and hacks. I don't know this woman, have no idea who she is, other than it seems like she got a picture of me many years ago with her husband shaking my hand on a reception line at a celebrity charity event. She completely made up a story that I met her at the doors of this crowded New York department store and within minutes swooned her. It's a hoax and a lie, just like all the other hoaxes that have been played on me for the past 7 years. And while I am not supposed to say it, I will. This woman is not my type. She has no idea what day, what week, what month, what year, or what decade this so-called event took place. And the reason she doesn't know is because it never happened. And she doesn't want to get caught up with details or facts that can be proven wrong. If you watch Anderson Cooper's interview with her, where she was promoting a really crummy book, you will see it is a complete scam. In the meantime, and for the record, E. Jean Carroll is not telling the truth, is a woman who I had nothing to do with, didn't know, and would have no interest in knowing her if I ever had the chance. Thank you. So then the proceedings came about. And remember, they created a law to sue Trump. She sued Trump to recover damages for defamation. Carroll 1 was delayed because Trump was still the president. Then while Carroll 1 was pending, okay, she sued him for defamation. She also got New York State to pass the Adult Survivors Act. And we've talked about this many times here. It was created by E. Jean Carroll and her lawyer, Roberta Kaplan, who lobbied to get the law passed. Roberta Kaplan even admitted it. She's like, yeah, we got that passed. As soon as they passed it, it gave victims of abuse a new 1-year window. Remember, there are statute of limitations. You lose the ability to bring claims once the statute of limitations expires. They opened it back up to allow her to sue. In 2022, she advised the court she was going to sue once the window opened, and then they did. Then 3 years after she initiated it, they filed new claims, and all the claims came about. Trial commenced on April 25th. It concluded. They brought in a bunch of witnesses. The 9-jury panel unanimously found Trump abused her, but didn't R her. The jury found that she was injured as a result and gave her $5 million. Trump moved for a new trial, and now here we are. They say Trump argues that the district court erred when it precluded cross-examination about DNA. She had a claim that she possessed Trump's DNA on a dress she was wearing from the day of the assault. Now, in a written opinion issued before the trial, the district court concluded that although her statements regarding the DNA were arguably relevant, their probative value was significantly outweighed by the reasons for preclusion under Rule 403. Now, this is a joke. If she says that she has evidence of DNA, why can't we ask her about that? I have the dress. I've got Trump's DNA on it. Great, go get it. Prove it. So Trump says, make her get it. Let us ask about it. The judge said, no, it's going to introduce unfair prejudice. It's going to confuse the issues. It's going to mislead the jury. It's going to waste everyone's time. And so they say, yeah, no problem. In a series of tweets, Carroll claimed she still had the dress. She posted these tweets back in 2020 and 21. She said that I have the dress from when Trump assaulted me. She believed the dress had Trump's DNA on it. Oh my goodness. She had had a DNA test performed on the dress, and the test showed, she said, that the dress had male DNA on it. She actually tested it? At the outset of this, Miss Carroll had requested a DNA sample from Trump for testing, seeking to confirm her belief it was his DNA, but Mr. Trump refused to provide the sample until the eve of trial. Now, the district court did not abuse its discretion in precluding cross-examination because they say Trump didn't give her the DNA. Now, first, the district court determined that the value of the line of questioning was low. There was no credible evidence that she lied about Trump's DNA. She was simply never able to confirm or negate the basis for this. She was never able to obtain a sample to compare. There's also like security reasons, okay, why you don't have the presidential DNA floating around. My understanding is they clean up the president's poo-poo when he's traveling around so that nobody gets his DNA, just to be clear on that. So like he's not just, oh yeah, here you go, have a strand of hair. Second, the district court also recognized that cross-examination, if you ask her about that, then it would open the door to questions about Trump's DNA test, why she couldn't get one. Then we'd have to bring in expert testimony on DNA. That would really bring in a bunch of stuff. And so we think that not getting into the DNA conversation was fine. If you would have allowed cross-examination on this, it would have been a trial in a trial about why he doesn't have Trump's DNA sample. Another problem, why didn't you file a police report? They did not let Trump ask this question. How would you bringing criminal charges be disrespectful to some of the people at the border? Couldn't ask her that. The district court, excuse me, correct me if I'm wrong, counsel, but I believe in the state of New York, private individuals can't bring criminal charges. We've been up and down the mountain on the question of whether she went to the police, so let's move on. You can't ask her why she didn't contact the police. Trump says, hey, we should have been allowed to ask her about why she didn't contact the police. She should have used the formal mechanisms for reporting the R that allegedly happened. Trump says that the judge improperly suggested that she was powerless to file a report. The district court, they say, though, did not abuse its discretions here. The district court permitted extensive questionings about her decision not to go to the police, and the court allowed other evidence on this point as well. And so by the time they got to this question, they already asked a bunch of other related questions, and so they're allowed to have reasonable debates on this. And finally, they say the district court did not abuse its discretion when it stopped Trump's lawyers from asking whether she went back to get video camera footage. They say no. It's well established here that you cannot improperly attribute testimony. Now, right before this question was asked, Ms. Carroll had testified that she's never been able to verify if there were cameras in the dressing room. Not one of the witnesses testified about location of cameras, and the store manager, Cheryl Beall, testified that she thought at the time that there were cameras at the main entrances and around the jewelry, but not in lingerie, and saying there were only a few cameras back then in the 90s. And so you can still emphasize that in closing arguments, and they did. So they conclude for us. They say, finally, Trump asserts that he's entitled to a new trial, arguing that the cumulative effect of the claimed errors affected his rights. But here, even assuming that there was evidentiary error, we're not going to grant you a new trial unless we think it is not harmless. We will deem an error harmless if we conclude that it's unimportant. And so that's what we say here. The jury made its assessment of the facts. The record was properly developed. Even assuming for the sake of argument that the district court erred in some of these rulings, which we reject, still as a whole, we're not persuaded that any claimed error or combination of errors in the district court's rulings affected Trump's substantial rights. And so all of those little tidbits that Trump's defense would have loved to have get in are all precluded. And so the district court's decision is affirmed. And as we saw from Trump's defense attorney or representative, Stephen Chung, they will continue to appeal this case. And so next stop will be the Supreme Court. We are expecting the Second Circuit to be liberal and to affirm the New York holding. But what will the Supreme Court do on these issues? Will they reverse this? Time will tell. We'll wait for Trump's filing. When that drops, we'll be here to cover it. Thank you for subscribing and joining us as we do.